Jordan Hayes adjusted his tie one more time before entering the gleaming glass tower that housed Morrison & Associates, one of Boston's most prestigious law firms. The firm occupied floors 47 through 52 of the Prudential Tower, with views stretching across the Charles River to Cambridge and beyond. He was 23 years old, finishing his second year at Suffolk University Law School, and according to his carefully constructed cover story, applying for Morrison & Associates' competitive summer associate program. His resume showed a 3.9 GPA, law review membership, and impressive moot court results, but it deliberately omitted one crucial detail. His mother was Federal Judge Patricia Hayes of the United States District Court for the District of Massachusetts. Judge Hayes had spent 30 years in the legal profession, rising from public defender to federal judge. Over her career, she'd noticed disturbing patterns in the legal industry, particularly in how elite firms recruited and hired attorneys. Despite decades of diversity initiatives, the legal profession remained overwhelmingly white at the partnership level, and complaints of discriminatory hiring practices persisted. So Judge Hayes had proposed an experiment to her Judicial Ethics Committee. With their approval and careful legal oversight, she would have her son apply to several prestigious firms using a resume that removed any hint of his judicial connections. He would present as exactly what he was, a talented black law student from a public university with excellent credentials but without the Ivy League pedigree that elite firms typically required. Jordan would document every interaction, recording conversations where legally permitted and noting patterns of bias. The goal wasn't to entrap anyone, but to observe whether firms practiced the equal opportunity hiring they claimed in their diversity statements. Morrison & Associates was the third firm Jordan had applied to. The first two had been professional if not welcoming, conducting proper interviews before ultimately rejecting him with vague explanations about fit and current hiring needs. But something about Morrison & Associates' reputation made Judge Hayes particularly interested in testing them. The firm was known for aggressive litigation, corporate law expertise, and a client list that included Fortune 500 companies. They were also known in whispered conversations among lawyers of color as one of the least diverse major firms in Boston. Jordan announced himself to the receptionist on the 47th floor. The lobby was designed to intimidate, all marble floors, contemporary art, and floor-to-ceiling windows. The receptionist, a young white woman with perfect makeup and a perfectly modulated voice, barely made eye contact. "Mr. Hayes, you're here for the summer associate interview. Have a seat. Someone will be with you shortly." Jordan sat in one of the leather chairs, observing. Over the next 15 minutes, he watched 3 other candidates arrive for interviews. All 3 were white. 2 mentioned Harvard Law, 1 mentioned Yale. The receptionist's demeanor toward them was noticeably warmer, her smile more genuine. At 10:17 a.m., 13 minutes late for his scheduled 10 a.m. interview, a man emerged from the inner offices. He was in his mid-50s, wearing a navy suit that probably cost more than Jordan's entire wardrobe, with Harvard Law cufflinks glinting at his wrists. Jordan Hayes. He didn't extend his hand. "I'm Richard Caldwell, senior partner. Follow me." Jordan followed Caldwell through the maze of offices, noting the sea of white faces, the occasional person of color in support staff positions, and not a single black face at the attorney level that he could see. Caldwell's corner office was everything Jordan expected. Massive desk, diplomas from Harvard and Yale prominently displayed, photographs of Caldwell with various politicians and business leaders, and windows offering a commanding view of Boston Harbor. "Have a seat." Caldwell gestured vaguely toward a chair while settling behind his desk. He picked up Jordan's resume, glancing at it briefly with an expression that suggested he'd already made his decision. "Suffolk Law," Caldwell said, his tone making it sound like a question and an accusation simultaneously. "Yes, sir. I'm finishing my second year." And before that you went to UMass Boston?" "Yes, sir. I graduated summa cum laude." "Right." Caldwell set the resume down as if it were contaminated. "And you're interested in corporate litigation?" "Yes, sir. I've been particularly drawn to securities litigation and corporate governance issues. I wrote my law review note on fiduciary duty standards in closely held corporations. Law review at Suffolk." Again that dismissive tone. "That's nice." The interview, if it could be called that, continued for exactly 9 minutes. Caldwell asked perfunctory questions, barely listening to Jordan's answers, checking his watch twice, and making no effort to hide his disinterest. "Tell me, Mr. Hayes," Caldwell leaned back in his chair, "why do you want to work at Morrison & Associates?" "I'm asking because, honestly, I'm not sure you'd be a good fit here." Jordan kept his voice professional. I'm interested in Morrison and Associates because of your reputation for complex commercial litigation. I believe my academic background and work ethic would be valuable to your team. Work ethic? Caldwell smiled thinly. That's important, certainly, but Morrison and Associates is more than just work ethic. We have a culture, a way of doing things. Our clients expect a certain caliber of representation. They expect attorneys who understand their world, who can relate to their concerns, who fit seamlessly into their corporate environments. The coded language was unmistakable. Jordan had heard it before, in different forms, but the message was always the same. You don't belong here. I understand the importance of client service, Jordan said. My experiences have taught me how to adapt to different professional environments. Have they? Caldwell looked skeptical. You see, our summer associates typically come from top-tier schools, Harvard, Yale, Columbia, schools where students have been groomed for this level of practice. Suffolk is a fine school, I'm sure, but it's not quite the same caliber. With respect, sir, I've competed against students from those schools in moot court and outperformed them. My GPA and law review membership demonstrate I can excel at the highest academic level. Caldwell waved his hand dismissively. Academics are one thing, practice is something else entirely. I've been doing this for 30 years, and I've learned to recognize who will succeed at a firm like this. It's not just about grades, it's about background, polish, cultural fit. What specifically about my background concerns you? Caldwell's expression hardened slightly. I'm not sure this is the right environment for you, Mr. Hayes. Maybe you'd be better suited for a smaller firm, or perhaps public interest work, government positions, legal aid, that sort of thing. Places where your particular background might be more. Jordan felt his jaw tighten, but kept his expression neutral. Every word Caldwell spoke was being recorded by the device in his portfolio, legal under Massachusetts' one-party consent law. Every assumption, every dismissal, every coded rejection was being documented. Are you saying you don't think I'm qualified for the summer associate position? I'm saying I don't think you'd be comfortable here. Look, I'll be frank with you. Morrison and Associates serves a very specific client base. Fortune 500 executives, corporate boards, high net worth individuals. These clients expect their attorneys to understand their world. They expect lawyers who went to the right schools, who belong to the right clubs, who understand how business is conducted at the highest levels. Caldwell leaned forward. You seem like a bright young man. I'm sure you'll have a successful career, but it might be in a different setting than Morrison and Associates. I'm actually doing you a favor by being honest about this now rather than stringing you along. So you're rejecting my application. I'm suggesting that there are better fits for your talents. We'll send you a formal decision letter, but I think we both know this isn't going to work out. Caldwell stood, clearly ending the interview. Jordan gathered his materials, shook Caldwell's hand with professional courtesy, and left the office. As he walked back through the firm, he noted everything. The stares from some attorneys, the way others looked right through him, the receptionist who'd already dismissed him from her attention. In the elevator down, Jordan pulled out his phone and texted his mother. Interview complete. It was exactly what we expected. Documented everything. Judge Hayes responded immediately. Good work. Come to my chambers this afternoon. We need to review the evidence. That evening, Jordan sat in his mother's federal courthouse chambers, playing the audio recording of his interview with Richard Caldwell. Judge Hayes listened with her eyes closed, her expression growing darker with each coded phrase, each dismissive comment, each barely concealed bias. When the recording ended, she opened her eyes. That's textbook discrimination. He essentially told you that you're not qualified because you're not from an Ivy League school and don't have the right background. He never explicitly mentioned race, Jordan pointed out. He didn't have to. Cultural fit, client expectations, understanding their world, these are all code phrases for racial and socioeconomic discrimination. Combined with the statistical reality that Morrison and Associates has virtually no black partners and minimal diversity at any level, the pattern is clear. Judge Hayes pulled up files on her computer. Jordan, you're the fifth person who's gone through this process. We've had a white student from Harvard Law, a white student from Suffolk, a Latino student from Boston University, an Asian American student from Boston College, and now you. The results are striking. She showed him a chart. The white Harvard student was interviewed for 45 minutes, given a firm tour, introduced to multiple partners, and offered a summer position within a week. The white Suffolk student got a respectful 20-minute interview and a polite rejection. The Latino student got 15 minutes and dismissive feedback about needing more experienced candidates. The Asian American student was interviewed, but subtly steered toward the firm's intellectual property department rather than the litigation positions she'd applied for. And me, 9 minutes, barely questioned about your qualifications, told you don't fit before you even had a chance to demonstrate your abilities. Judge Hayes leaned back in her chair. Morrison and Associates claims to be an equal opportunity employer. Their diversity statement talks about commitment to inclusion. But the evidence suggests they practice systemic discrimination. What happens now? Now we compile all the evidence, the recordings, the statistical analysis of their hiring patterns, the comparative treatment of candidates. Then we present it to the appropriate authorities, the Massachusetts Commission Against Discrimination, the Equal Employment Opportunity Commission, and possibly the Bar Association's Ethics Committee. Jordan felt a mixture of satisfaction and sadness. Mom, how many talented lawyers of color have been rejected by firms like Morrison and Associates over the years? How many never got the opportunities they deserved because someone like Richard Caldwell decided they didn't have the right pedigree? Thousands, Judge Hayes said quietly. That's why this work matters. We can't change decades of discrimination overnight, but we can hold firms accountable, we can create consequences for bias, and we can make it harder for the next Richard Caldwell to reject qualified candidates based on coded prejudice. The investigation into Morrison and Associates began quietly. The Massachusetts Commission Against Discrimination opened a formal inquiry based on Judge Hayes's complaint, which included the evidence from Jordan's interview and the comparative data from the other test candidates. The Commission's investigators requested 5 years of hiring data from Morrison and Associates, including all summer associate applications, interview records, and hiring decisions. They cross-referenced this data with law school GPAs, bar passage rates, and demographic information. What they found was damning. Over 5 years, Morrison and Associates had received 847 applications from qualified law students for summer positions, interviewed 127 candidates, hired 52 summer associates. Of those 52 hires, received 47 were white, 90.4%, interview latio. More tellingly, when they analyzed interview rates versus application rates, a clear pattern emerged. Black candidates with equivalent credentials to white candidates were 73% less likely to receive interviews, and those few who did receive interviews were interviewed for significantly shorter periods, and by lower-ranking attorneys. The commission also discovered that Morrison and Associates had an internal ranking system for law schools. Harvard, Yale, and Columbia were Tier 1 schools whose candidates received priority. Other schools, including Suffolk, were ranked lower despite having comparable bar passage rates and placement statistics. Richard Caldwell's interview notes were particularly revealing. Over 5 years he had interviewed 34 candidates. Only 3 were people of color, and his notes for all 3 included phrases like "not firm material," "better suited elsewhere," and "culture concerns." For white candidates, even those he ultimately rejected, his notes focused on credentials, potential, and specific skills. For candidates of color, his notes centered on vague concerns about fit and background. Morrison and Associates' initial response to the investigation was defensive. The firm's managing partner, Gerald Morrison himself, issued a statement claiming the firm hired based solely on merit, and that any statistical disparities were coincidental or reflected the candidate pool. But as evidence mounted, that defense became harder to sustain. The commission uncovered emails from Caldwell to other partners with subject lines like "maintaining standards" that discussed concerns about lowering the bar by considering candidates from non-traditional backgrounds. One email was particularly damaging. In response to a diversity initiative proposal from the firm's younger associates, Caldwell had written, "We need to be careful about appearing to engage in reverse discrimination. Our clients expect a certain caliber of lawyer, and we can't compromise our reputation for the sake of political correctness." 6 months after Jordan's interview, Morrison and Associates received formal charges from the Massachusetts Commission Against Discrimination. The charges alleged systematic discrimination in hiring practices, disparate treatment of candidates based on race, and creating barriers to entry that disproportionately affected attorneys of color. The firm now faced a choice: settle the charges with significant reforms and financial penalties, or fight in a public hearing that would expose all the evidence. Richard Caldwell became the firm's liability. Younger partners, many of whom had been uncomfortable with the firm's lack of diversity, pressured the management committee to take action. Several major clients, concerned about the reputational damage, threatened to take their business elsewhere. Within 2 weeks of the charges becoming public, Morrison and Associates announced that Richard Caldwell had retired from the firm. The firm also announced a comprehensive review of hiring practices, mandatory bias training for all attorneys, and a commitment to increasing diversity. But many observers, including Judge Hayes, were skeptical that surface changes would address deep cultural problems. The case eventually settled. Morrison and Associates agreed to pay a fine of $750,000 to the state, would establish a $2 million diversity fellowship fund for law students from underrepresented backgrounds, submit to 5 years of hiring audits by an independent monitor, implement blind resume reviews that removed school names and demographic identifiers from initial screening, would establish measurable diversity goals with consequences for failing to meet them. Richard Caldwell, now retired, found that his reputation followed him.
When he attempted to join another firms of counsel, news of the Morrison & Associates investigation made firms reluctant to associate with him. He eventually opened a solo practice, focusing on estate planning, a dramatic step down from his former position as a senior partner at one of Boston's most prestigious firms. 1 year after his interview, Jordan Hayes returned to the Morrison & Associates offices, but this time in a very different capacity. He was there as a summer associate, not at Morrison & Associates, but at a smaller, more diverse firm that had recruited him specifically because of his role in exposing discrimination in legal hiring. But Morrison & Associates had invited him to speak to their attorneys as part of their mandatory diversity training. Jordan stood in the same conference room where he'd once been dismissed, now facing 120 attorneys who were required to attend. A year ago, Jordan began, "I sat in Richard Caldwell's office for 9 minutes. In those 9 minutes he decided I wasn't qualified to work at this firm. Not because of my grades, not because of my legal writing, not because of any objective measure of ability, but because I didn't go to Harvard or Yale, because I didn't fit his mental image of what a Morrison & Associates attorney should look like." He paused, looking around the room. Mr. Caldwell made a lot of assumptions in those 9 minutes. He assumed that because I went to public schools, I couldn't understand your client's world. He assumed that because I didn't have certain pedigree markers, I lacked polish and sophistication. He assumed that I would make your clients uncomfortable. What he didn't know was that I grew up attending state dinners at the governor's mansion because my mother was a federal judge, that I'd spent summers interning at major corporations, that I'd traveled internationally and studied comparative legal systems, that I spoke 3 languages and had a network of professional connections that would have been valuable to this firm. But even if none of that were true, Jordan continued, his voice growing stronger, even if I had come from a working-class background, even if I'd been the first in my family to go to college, I still deserved to be evaluated on my qualifications, not on Richard Caldwell's assumptions about my worth. He pulled out papers. "These are my grades. My law review note on fiduciary duty was published and has been cited in 3 federal court decisions. I finished second in my class last year. I've been offered positions at 4 major firms. All of this potential was sitting across from Richard Caldwell, and he couldn't see it because he was too busy looking at what I wasn't, rather than what I was." One of the partners raised his hand. "Mr. Hayes, I want to apologize on behalf of the firm." Jordan raised his hand. "I appreciate that, but apologies aren't enough. What matters is whether this firm actually changes. Whether you can look at the next Jordan Hayes, who walks through your door and see potential instead of someone who doesn't fit your preconceptions." He addressed the room. "Most of you have never experienced being dismissed before you had a chance to prove yourself. Most of you have never walked into a room and known that people were making negative assumptions about your competence based on your appearance. Most of you have never had to be twice as good to be considered half as qualified. That's privilege. That's what it means to be automatically assumed to belong in spaces like this. And until you can recognize that your path to partnership was smoother because of factors beyond merit, you can't fully understand what candidates like me face." After his speech, several younger associates approached Jordan privately. "Thank you for doing this," one said. "Some of us have been pushing for change, but it's been difficult to get the senior partners to listen." Another associate, a black woman who'd been hired in the wake of the settlement, told Jordan, "I'm one of the first black litigation associates they've hired in a decade, and I wouldn't be here if you hadn't exposed what was happening. So thank you." These conversations reminded Jordan why the work had been worth it. The discomfort of that interview with Caldwell, the patience required for the investigation, the public scrutiny, all of it had purpose. 3 years after the incident, Morrison & Associates looked different. The firm had hired its first black partner, promoted from within after the settlement forced real attention to advancement opportunities. The summer associate class was genuinely diverse, not tokenism, but actual representation across racial and socioeconomic backgrounds. But cultural change was slower than numerical change. Some of the old guard resented the reforms, seeing them as lowering standards rather than expanding opportunities. Younger attorneys reported that bias still existed, just more carefully concealed. Judge Hayes, watching from her federal bench, knew that one investigation hadn't solved systemic discrimination in the legal profession, but it had created accountability at one major firm. It had shown that discrimination, even when subtle and coded, could be documented and prosecuted. And it had given other firms reason to examine their own practices before they became the next Morrison & Associates. For Jordan, the experience shaped his legal career in unexpected ways. He specialized in employment discrimination law, using his personal experience to inform his representation of clients who faced similar bias. He became a sought-after speaker on diversity in the legal profession, and an advisor to firms genuinely trying to reform their practices. And he never forgot the lesson of that 9-minute interview, that talent and potential come in forms that don't always fit traditional expectations, and that gatekeepers who can't see past their own assumptions do immense damage not just to individuals but to the entire profession. Richard Caldwell, in his solo practice, slowly faded from prominence in Boston legal circles. Whether he ever understood what he'd done wrong, Whether he ever recognized his own bias, no one knew. But his name became cautionary, a reminder of how personal prejudice, when paired with institutional power, could perpetuate discrimination for decades, until someone decided to document it, expose it, and demand accountability. That was the power of Jordan Hayes' 9-minute interview. Not just in ending one man's career at one firm, but in forcing an entire profession to look at how it hired, who it excluded, and whether its stated values matched its actual practices. The work was far from finished, but it had begun.
Thank you very much for listening. Please let us know what you think of this story in the comments. Don't forget to like the video and subscribe to the channel. Turn on notifications so you don't miss any other videos.